r/AskReddit by Reddit and chill. Lawyers of Reddit. What's your best most badass I rest my case moment? I was on the losing end of this one. I was representing a pro bono defendant who was attempting to regain custody of her children. The family division attorney was laying out his case to the judge for why my client wasn't ready, and his final point was that my client had refused emotional counseling to avoid violent fits of rage that she had inflicted on her children. On cue, my client jumps up screaming, "Uck you judge lady, you a stupid unt, uck you all for taking my ucking kids you ucking unts." I just caught the opposing attorney's smirk of satisfaction as I got up to usher my client out of the courtroom. Edit. In case you're feeling the slightest bit of sympathy for my client, here's some more background. Reddit.com link. It's probably better for the kids that you lost that one. If I was a lawyer, this is the type of case I wouldn't mind losing. It's for the greater good. Not having that type of person as someone that raises them is much better than anything I could ever gain from this case. A lawyer's job is only to provide a fair fight. When I was in law school, I had to argue a case for an exam. I was the last in my class to go, so there wasn't anyone arguing against me. I opened with a motion to dismiss and supposing had failed to show. The judge grading me chuckled and said, "Touche counsel." I still had to go forward, but we got off on the right foot and I ended up with an A. Genius. Damn. That move is even giving me a shit-eating grin and I wasn't there. I once had to appear on behalf of a former employer to provide a testimony, and no one from the defendant's side showed, not even their attorney. Our attorney moved for summary judgment. The judge was perturbed by this, and spent 20 minutes defending their case from the bench, with 0 defendants in the courtroom, until he finally gave up and granted our motion. Bloody judges. Not a case-winning moment, but a motion-winning one for sure. Think of cases like a big conflict, with motion hearings as little conflicts. Opposing attorney was insisting that Rule A meant they could do X. I tried, multiple times, to point out Rule A literally did not say that. During the hearing, the judge reached behind them, grabbed their rules of civil procedure, basically a dictionary of rules, placed it in front of the other attorney, and said, "Show me where Rule A says X." Other attorney did not take the hint, read rules out loud for a brutal 5 minutes, and gave the book back. I said, "Judge, I have nothing to add." It was pretty fun. Oh, that had to be excruciating for everyone, especially the court reporter. Opens PDF of rules, copy paste, adds a few ums and yak nows and someone sighs loudly in the background. I would love if stenographers did that type of shit. Fun fact, my mom used to be a stenographer. Opposing counsel decided that I had coached my witness and gave him lines to repeat, that he was lying. Short version is that he asked the witness if he spoke to me before he testified. Witness said he had. Attorney looked like he thought he had me. Attorney asked the witness what I told him, what instructions I gave him. Witness looked him dead in the eye and said, "First thing he told me was to tell the truth no matter what." He said the lawyer is never the one who goes to jail, that he isn't going to jail for me, and if I lie, I'm on my own. Attorney looked like someone took the air out of him. Everyone in the courtroom simultaneously looked at me. Only time I've smirked or laughed in court. I wanted to put my feet up on the table like I was Vincent LaGuardia Gambini, hands behind my head, and say, "I'm done with this guy." I had a trial against a guy who was self-representing and he was constantly asking my client about conversations she had with me. First of all, no, I'm not coaching her to lie, and second of all, there's a thing called privilege, which means the things we discuss are not compellable. It was an exhausting trial. Needless to say, he was ordered to pay about $1 million more than he actually owed. He could defend an innocent man all the way to death row. Never ask a question you don't know the answer to. Rookie mistake. I was prosecuting some kid. He had an antisocial behavior order, which meant that he was not supposed to go to a certain street. He had pleaded not guilty on the basis that he had not been there. I opened my cross-examination by holding up a map and pointing at the street. I said to him, "You went here, didn't you?" He said, "Yes. In England, we don't say I rest my case." Instead, I looked up at the bench, said no further questions, and sat down. It might not seem badass, but I got the defendant to admit the offense with one question. That never happens. Why can't he go to a certain street? Usually because going there is likely to cause some sort of issue with antisocial behavior. Maybe he was intimidating someone on that street, or was in a gang with someone who lived there, or something. An antisocial behavior order, ASBO, in the UK is a way of making basically not a law specific to one person. For example, it's effectively illegal for you to be out of your house after 10 PM. or associate with certain people, or go to certain places. I'm not entirely comfortable with the idea as I feel it is open to misuse, but I can see that if applied fairly and sensibly it's a useful tool. Misfits taught my non-uke behind about ABSOs. Corporate lawyer, so I don't have cases to rest. But once opposing counsel was forcefully insisting that it was ridiculous for me to expect a certain provision in a contract we were negotiating, and I pointed out that this provision was standard in his own firm's contract forms, as I knew from several prior transactions I'd worked on across from them. Pretty exciting stuff. He took it in stride and said, jokingly, well, of course it's fine when we ask for it. Why do you have the right to do that? We will never do that. Then why do you have the right to do that? It doesn't matter. We will never do that. Then why do you have the right to do that? And so on and so forth. Transaction law is the best. This is the exact reason I'm not a fan of transactional law. Currently in a banking seat, everything is circular arguments with no determination, and you have little involvement in the actual material decisions beyond the legal stuff. That, and the admin. Dear God, the admin. My wife is a corporate lawyer at one of the Golden Magic Circle firms here in London. She bloody loved it. I couldn't imagine anything worse. I'm a criminal barrister. I bloody love it. She can't imagine anything worse. Most of my solicitor mates are banking litigators. I represented a company that was sued for breach of contract by a former independent contractor. Dude basically alleged that my client wasn't paying him correctly in accordance with the contract. During his deposition, dude admits that he never reviewed any documents to make sure his allegations were true. Never reviewed his complaint before filing it to make sure the allegations in it were true, and had no idea whether or not my client actually failed to pay him in accordance with the contract. Basically, he tells me that he was suing my client because he didn't think their agreement was fair, even though he agreed to the terms when he signed the contract. The kicker is that he admitted that he owed my client money at arbitration. He tries to flip his story and starts giving testimony that is the exact opposite of his dep. So I whip out his transcript and undermine his testimony bit by bit. Needless to say, I won that case. Username checks out. Pretty satisfying story too. I didn't have a pink suit or a chihuahua, but I had just as much sass. Defendant in a bench trial for a speeding ticket said he couldn't possibly go as fast as the officer clocked him. He knew this because he videotaped himself accelerating from a full stop to the location of where the officer sat. His experiment showed his vehicle could only get to 55 miles per hour and not the 67 miles per hour he was clocked at. The aider then moved to have another speeding ticket issued because the actual posted speed limit was 50 miles per hour. 5 miles per hour over is probably just a fine and a few points. 17 over is possibly reckless driving depending on the officer's discretion. I'd take that. Yep, let's just ignore the miscarriage of justice and the corruption of law enforcement. Let's just slap another ticket on this and put him in his place. Hey, I'd rather take a 5 over ticket than a 17 over ticket. Did the judge grant her motion? You/don't PM me breasts said here. My wife and not me, and it was during sentencing. Mr. Defendant, local gang boss, you stated you are not and have never been in a gang. That's correct. Do you have any tattoos? Yep, I have a tiger on my calf and one on my chest that says GD for life. What does GD stand for? Gangster Disciples. But, I mean, no further questions, Your Honor. Good defendants, generous dudes, gorgeous duffel bags, so many other options. Guilty defendant. I rest my case, Your Honor. Complaining witness accused my client of harassment stalking. Said she told him numerous times that she wanted nothing to do with him. My client claimed they were dating, but whenever she got mad at him, she'd call the police and say he was harassing her. On the stand, she testified that she'd never dated him, never invited him into her home, wanted nothing to do with him, She presented a photo on her phone of him sitting on her porch to prove that he had come to her property. I asked the judge permission to look at the photos before and after the porch photo for context. A girl had dozens of photos of the guy, who was clearly her boyfriend. I showed her one such picture. This is Mr. So-and-so, right? Yes. In this photo, he's on a bed. Yes. The bed is yours? Yes. The bed is in your bedroom? Yes. You took this photo of him? Yes. And in this photo, he's wearing your brassiere? Yes. No further questions, Your Honor. That's really sad. I'm glad she got in trouble for this. Really takes advantage of a situation no one should have to deal with. Not clear if she got in trouble. We only know the defendant got off. Oh, wearing her brassiere. Ian Albert, I was in traffic court one time and saw a lawyer straight up murder a cop with words. The cop had previously testified that the weather on the night of the traffic stop was heavy rain and winds so strong that the defendant could only open his window 3 inches, and that the car had stopped on an area with very little shoulder, forcing the cop to approach from the passenger side, not the driver's side. The cop had then testified that he smelled a strong smell of alcohol on the defendant's breath. When the defense lawyer got up, he repeated what the cop had said almost verbatim and asked how he could have possibly smelled alcohol on the breath of someone on the other side of the car, through a 3 inches crack in the window, on a night with pouring rain and strong winds. The cop sort of opened and shut his mouth a few times, squirmed around in his seat, and said, "That's just what I always write in my log, to remind me that it was a DUI stop." The judge threw the case out. No motion to dismiss needed. Then he took a break and called the traffic prosecutor and the cop into his office. I'm guessing it wasn't for a nice spot of tea and some scones. Edit. Really, people? You've never seen Ianal in a comment thread before? How about writing DUI stop in the book? Much shorter. Good God, man. Because if he writes smelled alcohol, then it's an indication of probable cause and it's usually a good record for later reference in court. That is, unless it's across the car in the pouring rain through a small window crack. The scummy thing is that the cop writes it even if he doesn't smell alcohol. Because if he writes smelled alcohol, then it's an indication of probable cause, except in a situation where that didn't at all happen, in which case it should be regarded as perjury when he says it under oath. I'm relatively junior, so I'm hoping to beat this one day. I defend professionals and brought a motion to dismiss a case on the basis that the plaintiff could not prove my client was negligent as she had not served the required expert evidence. As opposing counsel and I waited for our motion to be heard, we were sitting in the courtroom. The judge, who I did not know and who had not read our materials, wanted to talk to the parties of a short trial which was to be heard after our motion was argued. That matter was also a professional negligence matter and the plaintiffs had no expert support. The judge then spent 10 minutes explaining that he had practiced in professional negligence for many years and was well versed in the evidentiary requirements to prove the elements of professional negligence. In fact, he said, I very rarely use the word impossible in this courtroom, but it is impossible for you to be successful without expert evidence. Our matter was then called and I reveled in explaining to the judge that he was about to hear a motion to dismiss a professional negligence case on the basis that the plaintiff had no expert evidence. I won. Did opposing counsel see it coming? That will be explored at opposing counsel's deposition for their own professional negligence. My sister got T-boned by a car, causing a concussion when I was younger. Long story short, we were in court with the judge, who asked the driver if he had ever sped before. No, Your Honor, I never speed, was his reply. The judge asked him a couple more times if he was sure, if he never sped, ever. The driver was adamant that he never sped and never had before. A few minutes later, my sister's lawyer gave the judge some paperwork. She read it and said to the driver, it seems that you have some past driving violations. Can you tell me what they are for? Speeding. The driver had to pay medical bills for my sister. I feel like never is not a word that should be said in the courtroom. Not to my recollection, probably would have saved an additional perjury charge. It's satisfying when a bad liar gets caught. A smarter person would say that instead. We had a case where opposing counsel was cross-examining our expert witness on hydrology regarding some silt runoff issues. Mr. Smith Wouldn't you agree that the book I'm holding is highly respected in your field and considered to be the gold standard on the subject? Witness: I am aware that it is highly regarded in my field. Would you be willing to explain, in your own words, what paragraph 610 on page 121 is describing? Witness reads the passage word for word. Yes, I can read, but could you put this passage in your own words for the court? Witness: these are my own words. I wrote it. We were the defendants. We were being sued by Idaho over silt in a lake. We were able to prove that we weren't responsible and prevailed. It actually originated from another site and entered the lake. Elsewhere, however, that site was owned by a very large corporation, and I don't think the Hoa wanted to fight with an entity that could fight forever. I'm guessing they were trying to discredit the expert witness. At least pick up a different book if you're trying this. LOL, this is fantastic. Please describe the OC's reaction in glorious detail. I do mostly solicitor work, so if I'm doing my job right I don't get a whole lot of these type of moments. That being said, I had a long time client who was being sued and I got to shut down the guy suing him in a very satisfying way. So my client had hired a guy, we will call Kevin, as basically a right-hand man for his company. The employment contract wasn't done yet, but they had an agreement that Kevin would work 6 weeks at a lower wage and then sign the contract and get the agreed upon wage. So the guy works decently for 5 weeks and then is given the contract to sign. He comes back to the owner, my client, and says that he has some small changes he would like to make. When the owner gets the contract back, he finds that the small changes involve removing the duties and responsibilities section, basically the job description, and the non-compete confidentiality clause. Not only that, but he has written in a higher salary than agreed and added a bunch of new benefits for himself. Obviously, my client tells him that he can either sign the contract as it was originally laid out or he can find himself another job. He takes the latter option, but he starts a lawsuit against the owner wanting to be paid for the 6 weeks he was supposed to work, which had already been paid, 2 weeks in lieu of notice and 5 weeks vacation pay. Classic Kevin. Seems Kevin moved on from making his teachers laugh to making the courts laugh. IP lawyer. Deep in a set of terms and conditions on a website, our client's details, name and contact details, were listed, so it is very evident that they just copy-pasted our client's legal terms and conditions and missed a couple of details they needed to change. I was handed the matter, did a quick Ctrl+F for client details, and it was an open and shut case. Not really that impressive, but saved me hours of time going through each term one after the other, noting exact similarities for a letter of demand. Welcome to the world of law, where we spend millions on technology but people don't know how to Ctrl+F or use a simple spreadsheet. It's not that they didn't know how to use Ctrl+F, it's that they didn't know they needed to replace anything else because even the lawyers don't read the entire EULA. I know this isn't the point of the post or your comment, but if the EULA is too long for the fluffing lawyers, I genuinely think it's unethical to hold up the expectation that users will read it. I saw another thread asking about this a while ago, and someone in there linked to this, which I actually really liked. Probably OP of the comment, you/Garrett Carroll. I remember that story. Man, that was a blast to read the first time and now the second time as well. Thanks for bringing it up again. Did the original person post it more than once? The comment had 1 like. Default. So I assumed no one saw it besides whoever just linked it. Great story, but not sure how they arrest someone for insurance fraud when he never filed an insurance claim. Edit. For the people who keep telling me that he was arrested for arson, not insurance fraud, please reread the story. He was arrested for both, only tried for the arson. Not a lawyer, but during a particularly nasty employment mediation hearing, I got to ask my former employer a question about payments per employment law. Me. Did you or did you not pay into state-mandated unemployment insurance fund for all your employees past and present? Silence. Mediator. Sir, answer the question. Silence. Mediator. Well, let me ask it. Did you or did you not pay into state-mandated unemployment insurance fund for all your employees past and present? Silence. Mediator. I'll take that as a no. Now, how can silence be taken as an admission of guilt? Its mediation, goodwill in entering into the process and answering relevant questions weighs heavily. Ah, that makes sense. Thanks. As a young attorney, I had stated a claim that an insurance company was dragging out a case in bad faith, in hopes that my elderly client would die before they had to pay him. I was requesting that the trial day be given priority due to my client's advanced age. The judge was no spring chicken himself, and seemed skeptical when he asked exactly how old my client was, maybe thinking that he was in his 70s and must merely seem ancient to a baby lawyer like me. When I responded that my client was 92, and the case has already gone on for 5 years, the judge was visibly shocked, and immediately granted my motion for priority, shutting down the insurance company's attorney's attempt to respond. They wrote us a check for $1 million the next week. Too bad those RS already deprived him of 5 years of enjoying that check. To be fair, the check would have been a lot smaller if they hadn't tried to wait him out. His actual damages were only a few $100,000 max, but the bad faith insurance claim opened the door for a much higher recovery, in excess of the policy limit. So when they saw we had a fighting chance of getting that, they just gave us the entire policy limit to settle. I was representing a woman with a severe neck injury. Opposing counsel presented a test result that showed her cervical exam was normal. I felt almost bad when I pointed out he had the wrong cervical area in mind. I wonder how red his face got. If I was that lady, I'd have made my neck injury worse from throwing my head back in laughter. I'm not a lawyer, but the most memorable court scene I witnessed was 1968, Sacramento car. I was waiting to be tried in traffic court, my usual speeding, before Earl Warren Jr., the son of the great Earl Warren of Supreme Court fame. The guy before me was being tried for reckless driving. When it got down to sentencing, Earl Warren Jr. ordered some nominal fine and that the defendant attend traffic school. The defendant got all upset and began ranting how he didn't need to go to traffic school. As the defendant slowed down, Earl Warren Jr. calmly stated, "Well sir, I cannot make you attend traffic school. I can only issue the order for you to attend. If I find after 2 weeks you have not attended, I will issue a warrant for your arrest and place you in county jail for 30 days, at the end of which I will run you the order for you to attend traffic school, so we can keep you going in and out of jail until you decide to attend traffic school." The guy just grumbled and walked out of court. Don't know if he did go. I certainly did when I got a similar sentence. Calm as a cucumber, this judge. Thanks for sharing, man. This made me chuckle. Yes, I was impressed the guy didn't rattle him at all. My one thought was, here's a guy who knows how to use his power properly. As I said, I liked to speed as a teenager and got to know who the good judges and bad judges were. Another judge I went before a few times was Peter Menino. I nicknamed him Menino the Meanie, the hanging judge. He always had the harshest sentences. Even his opening court speech was something like, "I'm not here to just collect fines. If I was going to do that, I'd put a cash register at the door." He was always half asleep on the bench and would only wake up to bang his gavel, pronounce guilty, with X fine or jail, and slumber off again for the next case. Ducking, like and subscribe.